Ask the Expert with Brenda Hollingsworth from Hollingsworth Personal Injury Law, and a lot of interest today about it. We've got a couple of callers on the line for us, so we're going to start with Jack. Good morning, Jack.
Good morning. How are you guys?
Good.
Hi, Jack.
Hi.
All right.
My question is, at the starting of the snowfall season, my roommate was visiting across the street in one of the buildings, and they weren't taking care of their steps. Now, she had to slip from the top about 7 stairs down. She went to the doctors, got her medical stuff and everything. She seemed to be getting better. Just recently, she noticed she's struggling walking a bit in the morning, and it takes about 2 hours to loosen up and everything like that. My question to you, is it too late to put a claim in, or how long do I have to put a claim in?
Yeah, so that's a great question, really common. So typically for a personal injury claim in Ontario for an adult, typically it's 2 years from the date of the accident.
Mm-hmm.
And you want to protect that limitation period because it's difficult to extend. There are some circumstances where it can be extended, but they're quite limited. So if you know about the claim and you know about the injury within that 2-year period, it is really a good idea to put the claim in.
So, but what he's saying, first snowfall of the year, that's totally within reason, especially, and we're only a couple of months after that. It's not. So, do you see that a lot?
It's really, really common 3 or 4 months because most people think they're going to get better, and they think I'm not going to bother with this because I'm going to get better. And that there is some wisdom in that approach, especially if you don't have sort of a real diagnosis like a broken ankle or something. Lots of slip and fall people wait. Now, the only warning, based on what Jack was saying, it sounds like it happened on private property. He was describing somebody falling on stairs at an apartment building, I believe. So in that circumstance, there's no problem bringing the claim now. But if your slip and fall is on municipal property, there is a law that says that you should give notice within 10 days of the fall. So just a letter to the clerk of the city saying, I slipped and fell on this location at this time.
Even if it's to advise them to salt it or
whatever.
Just have a record of that.
Right. So do it in writing, keep a copy, and get it there. Now, if you miss the 10-day period, there can be ways around it. There's legal tests to prove that it's still a valid claim. Mm-hmm. But if you are able to give that notice within the 10 days, it's way easier. And I've said it on the show before. If somebody calls us with a claim against the city for a slip and fall, we say, hang up, give notice, and call us back.
Good.
Yeah.
All right, let's jump to Tony really quickly here with a question. Tony, what is your question? Good morning.
Good morning.
Hi, Tony.
Hi. My question is, my girlfriend and I were in a rear-ended at a red light by a drunk driver, and my girlfriend was seriously hurt. I wasn't. I never pursued the lawsuit. We have a lawyer. She has a lawyer on it now, and this was in 2007. And I keep telling her to change law firms because this guy hasn't been doing anything whatsoever to help her in the situation. Now, the important question is, if we use another law firm, if she uses another law firm, do we have to pay his expenses for the last 5-6 years?
All right, Tony, thanks for the question.
Most of the time, problems between solicitor and client, lawyers and clients, are communication problems. So if you haven't done so, I urge you to speak to the lawyer, force him to meet with you and explain sort of your concerns. Often people are disgruntled because claims have taken longer than expected. If this person was charged with impaired driving and there was a criminal trial, it is not shocking that it's not resolved yet. So I'll just say that, that is a long time, and most claims don't take that long. But where there's an actual criminal charge, it doesn't shock me. But that being said, if you really can no longer work with a lawyer, typically you have to look at your contract with that lawyer to see what you have agreed to.
Right.
At our law firm, what the terms are is that if you decide you don't want to pursue the claim, or if you decide, heaven forbid, that you want another lawyer, you would have to pay for our time.
Yeah.
So that is because most of the time you get paid when there's a settlement, but if the person leaves before there's a settlement,
Right. You have fees sitting there.
Right.
That's reasonable. Right.
But very typically, there is a way to make a deal.
Okay.
So let's say Tony goes to another law firm. That lawyer, the new lawyer, can talk to the old lawyer and make a deal that will pay your fees out of the settlement.
All right, there you go.
So that's how it works.
But lesson from that, keep communication really open and between you, for sure, no doubt about that. And do your research ahead of time, I think, is another good one, too.
Yeah.
Auger Hollingsworth, Brenda Hollingsworth from Auger Hollingsworth here with us this morning. Thank you so much. Some really good information today. AskBrenda.ca is how you get a hold of her.